Legal Pond.
Welcome to today's episode of the Legal Pond. Today we are going to look at the history and formation of contracts. So, two things. We are going to look at the history pertaining to the development of contract law and then how a contract is formed. Let's get started. Welcome back. So let us start with what is contract law and how that law developed. I am going to summarize the history. As I told you, this channel is to summarize things for you. You know, for everyday life, we engage in a number of transactions. We engage in the buying and selling of goods and services. We engage in transfer of interest in properties and all that. Now, these relationships, these engagements create obligations and rights for us. And then they put us under an umbrella called contract. So the law that governs these relationships is what we call the law of contracts. How did the law of contract develop? So law of contract developed in pieces. You know very well that when common law started developing, it started with the writ system. So for whatever remedy you are seeking at common law, there is a writ that represents it. And some of these writs had the characteristics of protecting some of these transactions that we engage in. So in the olden days, it wasn't all forms of contract that had remedy at common law. For a transaction to be considered as a contract that will be remedied at common law under the writ system, that particular transaction must have its related rates at common law. So most of the times, it was contracts that were made under seal, that were made formal, that were only enforceable. So for the contract to be enforceable, it needs to be formal or it needs to be under seal. So for example, contract regarding debts, contract regarding covenants, accounts, and what have you. Those were the only forms of contract that could be remedied at common law because they were made in a formal way. What it meant was that if the contract was made informally, then same cannot be enforced at common law because you will not get any remedy. There's no rate related to those informal transactions. So going forward, there was an increase in informal transactions regarding merchants and even the ordinary people. A lot of informal transactions were going on. So the courts and the people themselves were seeking for flexibility with the laws of contract so that they can enforce those transactions which were made informally. This led to the development of a concept called assumpsit. Now, it developed around the 14th and 15th centuries. And then the concept of assumpsit was such that a contract will be enforced because you've made an undertaking. So it is not necessarily about you making it formally, but then the fact that you've made an undertaking, the contract will be enforced. So assumpsit entitled parties to bring actions to enforce mere promises. Now, assumpsit had two branches of actions, which were actions for assumpsit nonfeasance and actions for assumpsit misfeasance. Now, assumpsit nonfeasance means that the person has failed to perform the promise he gave, while assumpsit misfeasance were for actions where the person promised to perform a certain act in a particular way, but then he has failed to perform in that way. So with assumpsit misfeasance, there is performance, but then the performance is defective. Assumpsit nonfeasance means the person has failed to perform at all.
These actions were available for informal transactions.
Now, as I said, assumptions came up to resolve or enforce simple promises which were not formal. But then for that promise to be enforced under the assumption concept, that promise must have something we call consideration. So it is within that era that the concept of consideration also came about. Because the transaction you are seeking to enforce is not formal in nature, something must be done to make that transaction enforceable. And that is what we call consideration. So it is after the development of consideration that the law of contract covered both formal and informal transactions. Then later, around the 17th and 19th century, the law of contract revolved around certain elements, which we will look at later. So that is how the law of contract developed in short. Now, what is contract itself? What is contract itself? Sir Frederick Pollock defines contract to be set of promises which the law would enforce. Set of promises which the law would enforce. That is what he calls contract. Now, for there to be a contract, there must be agreement between the parties. How do we know that the parties have an agreement? Because per the definition that we've learned from Sir Frederick Pollock, a contract involves set of promises or an agreement which will be enforced by the law. What it means is that there are some agreements, even though they are agreements, they will not be enforced by the law. So the question is that, what will make an agreement enforceable? Let us first look at how an agreement is made, and later we will come and look at the things that will make an agreement a contract, because an enforceable agreement is what becomes a contract.
Now, an agreement is when two or more parties reaches mutual understanding. And then there are three things that makes that mutual understanding works. That is one, there must be an offer. Two, there must be acceptance. And then three, the parties must be at a consensus addendum. So for us to say there is an agreement, one party must have made a proposal or an offer, and then the other party must have accepted. Then they must have agreed, that is, the offer and acceptance being made must be about one particular subject matter. That is when we say the parties are at consensus addendum. Now, for us to know that the parties are at consensus addendum, that is where the problem lies. And then two tests has evolved as to whether the parties have actually agreed on a given subject matter.
Now, previously, for the court to come to a conclusion that the parties had an agreement, they used a test called the subjective test. And the subjective test is such that it looks at what the parties, from the perspective of the parties, what they intended to have agreed upon. So the parties will tell the court that I thought I was doing A, and the other party said, I thought I was doing B. Immediately they come to that point, it means there is no agreement between them. The reason is that the court will see them as not being at consensus addendum, meaning they do not have meeting of minds. So there is no agreement between them. So you look at earlier cases like Raffles versus Wilshire House, for instance. You notice that when the parties were entering into the agreement for the shipments of the goods involved, I think 125 bales of cotton, the parties agreed on a ship. But one of the ships were leaving Bombay in October. The other was leaving in December. But the ships were having the same name. So you notice that one of the parties thought the shipment was going to be done by the ship that is supposed to leave in October, whilst the other party thought otherwise. So on that grounds, the court noticed that the parties did not have meeting of minds concerning the ship or the vessel to carry out the voyage. That was how the court came to the conclusion that the parties had no agreement. But the question is that if we continue to apply or rely on the intentions of the parties themselves, then we are likely to come to a conclusion that they have no agreement, because a party who is being at disadvantage will likely say different things from what he actually intended. So this particular subjective test started failing. And because of that, another test came up, which is called the objective test. Now, the objective test was propounded in the case of Smith versus Hughes. Now, the objective test looks at the surrounding circumstances of the agreement or the transactions or negotiations that the parties had to come to a conclusion whether they had an agreement or not. Now, to apply the objective test, the court uses a principle or a test called the reasonable man's test. What the reasonable man's test means is that the court will look at the transaction and then conclude on how a reasonable man or an ordinary man of prudence will see the contract to be. So if an ordinary man will be able to conclude that what the parties agreed upon or what the parties has done amounts to an agreement, then the court will hold that there was an agreement, irrespective of the actual intentions of the parties. So when you look at Smith versus Hughes, for instance, per what the parties were saying, clearly you could see that the seller thought he was selling new oats, whilst the buyer in mind thought he was buying old oats. But the question is, how do you know who is telling the truth? So it becomes necessary for us to use the objective test. And the court considers circumstances surrounding their agreement or surrounding their transaction, including the fact that the sale was even done by sample sale, to come to the conclusion that there was an agreement and that there is a binding contract. When you look at a case like P.Y. Atta and Sons Limited versus Kingsman Industries,
you notice that in that case, the plaintiff had received a lease over a land from the government. And then part of that land, he entered into agreement with the defendants for use of part of that land. Now, the habendum that conveyed the land stated that it covers the unexpired terms, suggesting that they have done an assignment. But then when you look at the clauses of the agreement, it had clauses concerning rents, restrictions on assigning, restrictions on subletting, meaning that the terms depict a sublease. So now the question was whether or not that particular agreement was an assignment or a sublease. And then the court said that if the parties have an agreement and then the terms are ambiguous, then the court must ascertain the intentions of the parties objectively by reference to the whole document, their conduct, and the surrounding circumstances. Now, this thing that the court said is what we call the objective test. By looking at the whole document, the conduct of the parties, and the surrounding circumstances to come to the conclusion that yes, they have an agreement. So in that case, the court held that, using the objective test, the court held that the agreement was an assignment and not a sublease, because of the fact that they indicated that it conveys the unexpired residue of the lease.
However, if the transaction between the parties have clear and unambiguous terms, then the court is going to enforce it as it is, just as we had in Tamplin versus James. So the fact that we have the objective test does not mean that every time we have to use the objective test. No. The objective test comes in when there is conflict as to what the wording of the transaction between the parties means. But then if the terms stated by the parties are clear and unambiguous, the court is going to enforce it. So that is how the court is able to come to the conclusion that there is an agreement between the parties. Now, after making an agreement, after knowing that there is an agreement between the parties, what will make an agreement a contract? There are about five factors or features that makes an agreement or that graduates a mere agreement into a contract. And those things are that, one, there must be a clear offer and acceptance. So there must be an offer, there must be acceptance.
For us to say there is an agreement,
the third thing is that there must be consideration. The next thing is that there must be intention to create legal relations. Another thing is that the parties must have capacity to enter the contract. I am taking it again. There must be an offer, there must be an acceptance, there must be intention to create legal relations, there must be consideration, and then also there must be capacity. That is, the parties must have the capacity to enter into contract. So this is how a contract is made. There must first be an agreement. Then the agreement must have the features of a valid contract. But how do we get an agreement? We've gone through the history. So in our next video, we are going to pick these elements of a valid contract one after the other and then talk about them. Once again, if it is the first time you are coming to this channel, try and subscribe and hit on the notification button so that you'll be notified anytime a video is posted. See you in our next video.
The Legal Pond.